Hello, I'm Ben Kritz, and I'm here with attorney Monalisa Dimalanta, who is the chair of the Energy Regulatory Commission, an agency that figures quite prominently in all our lives as long as we have electricity in our homes. And we were going to discuss a few current issues and hopefully a little bit of an outlook for the year and the years ahead. There have been a lot of good developments since Attorney Mona took over the ERC, and of course there are a lot of challenges too. So let's get into all that. And thank you for coming out on a busy day. And I know what your schedule is like. Let's talk about some of the hot button issues that have come up lately. Probably the biggest one, or the top of mind for most people, at least in this part of the country, is the recently completed CSPs of Meralco, wherein the per kilowatt hour rate was around 7 pesos.
More than 7.
Yeah, a little bit more than 7 pesos for all of them. However, there has also been from several directions, it has been pointed out that that is probably about 2 pesos higher than it really ought to be, given the way the market works and everything. Now, the explanation that everybody has heard about that is that the slightly higher rate, well, for one thing, it guarantees a supply of power for a long period of time and will help to support investment in new generation, which is needed. However, is the rate something that ERC needs to take another look at? And if that is a valid explanation, how do we monitor and ensure that that little bit extra, that premium that everybody is paying, is actually being put towards capital expenditures for new generation?
Thank you. Thank you, Ben. But first off, thank you for the invitation. It's always good to have an opportunity to discuss what we are working on at the ERC, and I always learn something from you anyway. So it's good to have this conversation. So first, on that question with regard to the Meralco CSPs, you're right. ERC will need to look into that, not only because of comments about how whether the rate is high or whether it's the right rate, but because it is our mandate to really look at those rates and approve those rates. So not whatever rates were awarded by Meralco pursuant to their CSPs are not actually final yet until the commission gives an approval to the rate that should be passed on by Meralco to its consumers. You've touched on a couple of things that are going to be part of the consideration. Meralco has, by the way, not yet formally applied for those PSAs. I think there's only one that has been filed with us, which is a coal. Among those awarded one is a coal contract, I think, and 2 natural gas, 2 or 3 natural gas PSA. So only the coal one has been applied with us yet. But you've touched on a couple of considerations when we review this. You mentioned the idea of promoting new investments, and of course we need to encourage investments in the power sector, and having a bilateral contract, as you know, is an attractive element as far as lenders are concerned. So it will definitely attract investors. But I think one of the things we will consider is the fact that, are these really new plants? Are they the plants that are still going to be built or not yet operating in the system, such that that objective is a fit with the justification for the rate? So that's one. Second is, I think, some concerns raised on the fuel. I think, particularly for the most recent one that was awarded, which is a natural gas, a PSA with a natural gas facility, the issue on the source of fuel is, I think, is a big concern, especially now that we know that at least for the medium term, the sourcing it from sourcing significant volumes from Malampaya is not going to be
Right.
a likely
That's
scenario,
definitely got a shelf life.
which means that the source will have to be imported LNG. So we'll need to factor that into our analysis as well. So those are just, I think those two big issues would definitely be part of the evaluation of the commission when these are submitted for approval. The capacity fee, or the fixed component of the rate, and then the second would be on the fuel recovery.
Okay, so only one of them has been submitted so far. Have they given you any indication of when they intend to submit the other ones?
Yes. I think the other ones are undergoing what we call pre-filing. They're completing the documentation so that when they submit the application with us, all the supporting documents would already be completed, because the clock starts. As you know, we're now bound by a timeline under the EBOS.
Right.
And so before the clock starts, we need to make sure that all the supporting documents are already in place.
And those have to be filed jointly. Both the supplier and Meralco has to.
Correct.
Has
Under
to do
the
the work
CSP,
together. Yeah.
under the CSP guidelines, the distribution utility and the supplier have to jointly file the for approval of their PSA.
Okay. Now, just out of curiosity, I think I know the answer to this, but for the benefit of those who don't, to what degree can the ERC adjust the rate or suggest an adjustment to the two parties in the contract? So for example, they file for approval of a rate that's, say, 7.14. I think that's what one of them is. And can ERC then go, well, okay, everything is in order here, but your rate should be 6 something or 5 something, whatever, whatever you calculate it to be.
Yep.
What are they then bound by, by your decision, or is that something that is a negotiation between ERC and the parties?
Well, never a negotiation. That's one. It's never a negotiation. As they say, you don't negotiate with the regulator. So it's never a negotiation. But there is a two-part evaluation that we undertake. First is a review of the process. So making sure that the CSP, or the competitive selection process, is in compliance with the guidelines that were issued by the commission. All the requirements are present. All the parameters are observed. So one is a process review. If it fails the process review, we don't even consider the rates, because the process is already flawed. And there's already a Supreme Court decision that said if the process is flawed, we have no choice. We have to invalidate the entire thing. So, but if it passes the process review, then we go to the rate review, which allows us then to review the components of the rate. And most distribution utilities, Meralco is one of those who have a good rate structure in their CSP. So they really break down the components, and we're able to determine not just the reasonability, but the accuracy of certain rate components. For example, I mentioned earlier, if there's already an existing plant that is awarded a contract, then we do have data about that plant, whether it's the capacity fee of that plant, its reliability, its efficiencies. We have records of efficiencies of the plant, so we can vet from our own records whether the translation of those components to a peso per kilowatt hour rate an accurate translation. And those are the parameters of the rate review, and we make adjustments based on the results of the parameters of the rate review. So it's not like the headline rate is 7.14 and we say it feels like it should just be 6 and we reduce it to 6. It's a detailed review that then results to an adjustment,
Right.
if an adjustment is called for.
Okay. Okay. Let's talk about another thing that is kind of faded from the public attention, but might come up again. The mess in Panay Island at the beginning of the year, last month. At after the dust kind of settled from that, you had announced that ERC was conducting a review. Have you come to any conclusions yet as to what the cause or causes and who may be to blame in that? If not, do you expect to soon? And more importantly, I think for the people who live there, what recommendations may you make to prevent that from happening again?
Okay.
It's already happened twice, so
Yes.
I think they're probably tired of it.
Well, we cannot afford to get tired of it, right? Because we need to make sure that, as you said, that it doesn't happen again, or that if something like that happens again, that it will not create the what you call the mess that was the mess that it had created. So the dust may have settled as far as the public eye is concerned, but definitely it has not settled yet as far as we are concerned. The investigation by the Interim Grid Management Committee has already been completed. They've submitted their report to us. We've also made comments and requested for clarifications. Then they submitted their clarifications. And we do have currently, yesterday was the first day of the formal hearing, formal investigation on this. There's a public hearing that we needed to pursue following the report of IGMC, the Interim Grid Management Committee, because based on the results of the review or the analysis of the IGMC, there is no, it's the findings are inconclusive. They need more information, they need more data, not just from NGCP, but from the generators
Right.
that were involved. So the commission has decided to formalize the investigation so that we can also, one, compel the production of documents, because the IGMC could not compel the production of documents. Second, so that we can also issue the proper order if certain actions need to be taken that could be time bound. And there were recommendations from the IGMC report for certain actions to be taken within a period of time. So the commission decided to formalize the investigation. So it's ongoing now. Yesterday was the first hearing. NGCP presented again their sequence of events. IGMC presented their findings as well as their recommendations. We will have a continuance of the hearing, so that each of the generation companies that were involved will also share their version of the events, and then our own market operation service that did their own analysis from the generator's perspective are also going to disclose their findings on the performance of the generators, because the IGMC reviewed the NGCP response, our MOS reviewed the generator response, and then we're putting together the full picture based on the findings, and maybe once we get the additional information that we need.
Okay. All right. So that's something it was a complex situation. It was apparent that it was when it happened.
But maybe I can share something that because we've been monitoring, of course, very closely the situation in Panay, and over the last 48 hours or maybe even more, there have been instances like I think yesterday, one of the units of PEDC went on unplanned outage. But
They
it was,
seem to have
I know, right?
problems with that.
Actually, it was again a nervous
Hmm.
situation, but I'm sure the people in Panay hardly felt it because there was immediate response, and now because it's clear that the system operator can, if needed, um, conduct load dropping, then they have been notifying the distribution utilities that this happened. There's an unplanned outage. If necessary for system reliability, we will need to drop some loads. So everyone is prepared. But so far, no dropping has happened. But the good thing is it's now a better orchestrated, I think, response from all the
Okay, well,
stakeholders.
that's whatever else may be found in your inquiry. That is
That
perhaps
alone,
it perhaps is
yes.
a positive thing to say about NGCP because, as you know, they do bear the brunt of a lot of criticism.
Mm-hmm.
Sometimes deserved and maybe sometimes not.
Mm-hmm.
So that's good to know that they
Yes.
seem to have gotten a handle on that
Yes, yes.
and
And you could feel at least
can
because
minimize problems when they
correct.
happen.
Correct. Because we're part of this messaging group where updates are given every 15 minutes, and you can tell that the SO is on top of the, at least this time around, the SO is on top of the situation, and that gives confidence, right, for
Hmm.
the stakeholders that the system operator who has the ability to see the entire system is really on top of things.
Okay, well that's good to know. Speaking of NGCP, one of the things that you've been working on for quite some time
Mm.
is the long overdue rate rebasing
Yes.
exercise.
Yes.
How is that coming along?
Okay.
Are you getting near the final
Yes,
stretch for
yes,
that?
yes, yes. We're on track. We're targeting the first quarter to complete our all the evaluation. All the reports from the consultants are in.
Hmm.
Because as you know, we rely heavily on consultants for these type of work. So there was some delay because of the Christmas break on the submission of reports of some consultants, but now all the reports are in. So the commission has started the evaluation for the 2021 to 2022 phase, and we're putting it together. And our target is still to release the decision and have a new set of rates by the end of the second quarter of this year.
Okay. Well, that's good too. And I think one thing you've pointed this out in in other venues that
Mm-hmm.
you, since you have taken your position, you've had to do an awful lot of catch up work in the ERC. So I think it's good that you're actually making progress on some of these. This is important things that should have been done
Mm-hmm.
much earlier, and
Mm-hmm.
for various reasons were not. And given everything that you have to juggle, it's good that there's some progress being made. Um, this one issue here caught my attention, and I sent you my notes earlier, so you know what my thoughts were. But the San Fernando Electric
Mm.
Cooperative up in Pampanga, yeah.
Yes. Yes.
Um, the Court of Appeals recently struck down most of your refund order against them for overcharging customers, um, which which is anytime the courts get involved in something, it seems a little tenuous, kind of breaking the process. But this one stood out to me because, and you're an attorney and I am
Mm-hmm.
not, so guide me here. But it seemed to me, to my non-lawyer mind, that the Court of Appeals reasoning was quite shaky in that the prescribed penalties for a finding on your part that
Mm-hmm.
the cooperative had overcharged its customers, did not specify that a refund be given. Now, as I understand it, the Court of Appeals didn't have any problems with your finding because they upheld the
penalty.
21.6 million fine that you had levied, but they said that there was no basis for ordering a refund. Now, correct me if I'm wrong, but if the issue is an overcharging issue and the court decides that yes, you were correct in determining that there was an overcharging issue, wouldn't that imply a refund to the customers who were overcharged? Am I right, or is there something big that I'm missing here?
That's also what we are that we have put in our motion for reconsideration in that decision. Our counsels, the Office of the Solicitor General, is the one that put together our motion for reconsideration. They're representing the ERC at the Court of Appeals, and that's what we basically, in basic terms, that's the position, that's the argument. That of course we are grateful that the court upheld the penalty, our finding that it wasn't that there was no basis for the
because it is quite a substantial amount of money due back to
but also
customers.
because the situation persisted for a long time. I think that accounts for the huge amounts of refund. So what the Court of Appeal said was that yes, ERC, you are correct in imposing the fine or the penalty, but it's premature in a way to require the refund because you did not hear them out about the refund. So we're sort of trying to convince the court that the refund follows. The refund is a consequence.
Right. But you did afford them you did hear them out whenever you were making your initial decision of whether or not they overcharged their customers.
Correct.
They did have a chance to present their case, did they not?
We're hoping that we would convince the court that the refund is a consequence. It's not a separate. Actually, maybe the misappreciation lies there, that it's a separate, that it can stand separately from what was imposed, from the act for which the fine was imposed. It's not. It just flows from the fact that there is a violation. We impose the fine, and since that violation included collection of amounts that shouldn't have been collected, then what shouldn't have been collected should be given back.
Right.
So that's how we interpreted it. But
it's not a penalty, in other words.
Yes, it's not a penalty. It's not an additional penalty. The penalty is really just a fine, which goes to the ERC. The refund goes back to the consumers.
Well, it's a penalty for the consumers who are out. How much was it? It was
2 billion, I think.
Yeah, it was a large amount of money.
Yes.
Well, I hope that I hope that your motion prospers, because the logic just didn't seem to work there.
I cannot say more about that.
Yeah, I understand. I certainly can. And it's such a tricky balancing act for you, to regulate fairly. All these sometimes competing interests, and then to have a court kind of drop into that process. The courts do serve a purpose, but it just makes everything so much harder.
I think what makes it harder, and I must point this out, because one, we are a quasi-judicial agency. So our decisions are really subject to review by the courts. So it's not like the courts are meddling into or unduly dragged into our issues. That's really how our system works. Our decisions can be reviewed by the courts, by the Court of Appeals or the Supreme Court. So that's one. We're only a quasi-judicial agency. Our rulings are really subject to their review. But the second thing that, and I think people wouldn't really mind, the industry wouldn't be, should not be nervous about that, because in fact, well, as a lawyer, I welcome that. We also want affirmation from the court that
Right.
we're also doing the right thing, or correction if we're not doing the right thing. So that's one thing I appreciate. But I think what the danger or the increase in uncertainty happens because of delay.
Okay.
Because if our decisions are questioned, regulators' decision, not just ours, but the decisions of the regulator, of a technical body, are brought up for review, and it takes, for example, 10 years before the decision is issued, then imagine that 10 years worth of uncertainty. That has value. And this is one thing that, in the commission, I must say, we also need to realize sooner that even delays in our decisions have peso equivalent, have dollar equivalent. There is a price to uncertainty. So I think if that delay is addressed, then we wouldn't fear so much that things are reviewed by the courts, or things are subject to review, if decisions are made faster. Same lesson goes to us.
Yeah. Well, I know you've been working on it. Maybe they need an anti-red tape law to apply to the judicial system.
It's not subject to
Yeah,
our yes.
I know that's wishful thinking, but there should be some, if not hard and fast, timelines. There should be some, standards of guidance. Like, look, if we need to review an ERC decision, that review needs to take place within 6 months, or whatever's a reasonable amount of time. Otherwise, it will lapse into
Correct. And
being
there
official.
I think, to be fair to the Supreme Court oversees administratively all the courts in the land, and there are some efforts to do that via appointing special courts, courts that would have the expertise. Because sometimes what's taking it too long is, you need to understand the technical aspects of the industry, and if you need to do it, if you have different courts where the expertise need to be studied, need to be gained, then you'll really have delay. So the appointment, I think, of special courts facilitate the process, but I don't know if we have enough special courts around.
Yeah, I mean that it's, the idea of special courts is fine, but you do need the people who are both competent technically and good judges, to fill that, and that's a big ask, perhaps. Another thing that happened recently that I think may have upset a few people is that last month you reinstated the feed-in tariff, and your explanation at the time was that the fund that the feed-in tariff goes into was being depleted because it had been suspended for a length of time. Well, that explanation makes perfect sense. However, I don't think either the ERC prior to you, because of course the feed-in tariff has been around for a long time, nor the Department of Energy has really explained, to the unlearned, what exactly is done with the feed-in tariff money, and how do you determine the rate?
Okay.
And that's okay. That last is a bit of a trick question, because I've had it suggested to me by, I won't say who, that it tends to be perhaps a bit arbitrary, the rate, which I'm not sure how that works either. So, in as simple terms as you can make it, why is it important that we all pay that feed-in tariff?
All right. Okay. So maybe first, a clarification on the terminology. So the feed-in tariff is the rate that goes to the feed-in tariff is the rate for the different renewable energy plants that we have in the system. There's a feed-in tariff for solar, so there's a rate for solar plants. There's a feed-in tariff or a rate for the wind plants. There's a feed-in tariff rate for what we call the run-of-river hydro plants. There's a feed-in tariff rate for the biomass plants. So far, they are what we call the fit plants, the plants that are entitled to the feed-in tariff. They are all, as you know, we operate under a gross pool system. So everyone, Luzon, Visayas, and Mindanao, now that Mindanao is also connected to the entire system, all of our power plants all of the power plants in the country offer their capacities to the WESM, and they're all dispatched by the WESM. Feed-in tariff plants enjoy what we call the priority dispatch. Whenever the sun is up, it gives, and the solar plant is up, they need to be dispatched. So they bump off everyone else because whenever they're ready, the system is fed by the solar plant, the wind plants, the run-of-river plants, well, biomass is a bit tricky. There's a certain distinction because it's not intermittent. But the intermittent plants, whenever they're ready, they take the first dibs in the system. That means that whether we like it or not, we are served by the solar, wind, and run-of-river hydro. So um, we pay for the generation of those plants via what we call the FIT allowance, the feed-in tariff allowance. That is the peso per kilowatt hour that's charged from us, from all the users of the system, because we don't know whenever we are sourced by the solar,
Right.
hydro, and wind. So it's collected from all because the assumption is we're all served by them as well. So what we had suspended last time is the collection of the FIT all. So does that mean that the FIT plants were not paid? No, they were still paid. They were still paid one part from the WESM, whatever is the rate at the WESM at that point in time. And the difference is sourced from the FIT all fund. The fund where all our contributions via the FIT allowance is pooled, and that's the fund that you were referring to. So for a long time, because WESM was the FIT all amounts were being collected from all of us, and it's at less than 4 centavos from each one of the consumers being pooled in this fund. But the WESM rate was quite high. So there was no need to dip from the fund because the collection from the WESM was enough to pay out all the solar, wind, and hydro plants and the biomass plants. So the fund was very healthy. So what we did in December 2022 was to suspend the collection first of that 4 centavos from all of us because the fund had enough to pay out for a few months. We thought it would last for just a few months until it lasted for a year. That the fund was healthy until the fund was not healthy anymore. And then that's when we started saying, okay, we need to resume building up the fund again and started collecting the less than 4 centavos from everyone. So how do we land at that now 4 centavos? It's actually an application based on an application made by Transco. Transco is the manager of the fund, the administrator of the fund. So they compute all the feed-in tariff, the FIT rate that is due from all the solar, hydro, run-of-river, and biomass plants based on their estimated generation, meaning the kilowatt hour that they will produce over a certain period. They compute that versus some administrative fee that Transco also collects versus their projection of the WESM rate. Because again, the fund is supposed to make up only for the difference from what's collected in the WESM and what's due the RE plants over the total demand, meaning what we will all consume. And then they come out with a rate that they apply with the regulator, and then we also vet that and we determine what is going to be the FIT allowance rate for this year that will be collected from all of us. So there's I wouldn't say complex. It's not even complex process. It's actually just math. Um, but math can be complex also. Sorry. So, but it's not very complicated compared to, for example, the reset process. Now that's
Right.
complex, but the setting of the FIT allowance is not a very complex process.
Okay. Um, Well, I have time for just a couple more
Mm-hmm.
questions. I think one interesting thing, and that this somewhat relates to NGCP because of all the arrows shot in their direction last month when
Mm-hmm.
the Panay issue. But President Marcos recently floated the idea of what do you call a third party developer to help
Yes.
speed up grid connections and grid expansion. And I'm not sure what he meant by that. I'm not sure he was sure what he meant by that, because that just simply sounded like, to me, like allowing NGCP to outsource some work. Or what did he mean, have
Mm-hmm.
another, which would not be a third party, it would only be a second party in this case, have another grid operator
Correct.
come in. And so if it's what I think it is, it's just allowing NGCP to, pull in some more
Mm-hmm.
resources to get their work done,
Mm-hmm.
basically they're subcontracting it. Is that something that ERC would even need to get involved
Approve
in too
or
much as far as approving or overseeing it?
we don't approve the subcontracting arrangements of NGCP.
That's what I thought. Yeah.
Although we issued recently the procurement guidelines for regulated entities,
Hmm.
for example, and it applies not just to NGCP but all private distribution utilities as well. That we required for them to make sure it's competitive and all these things. So,
Right.
but again, not on a
That's
per contract.
that's fairly general though,
Correct,
and
correct. So
more
we
or less
don't
good
approve on
practice kind of
a
stuff.
we don't approve on a per contract basis. But I think the driver there is really to make sure that the projects that are the critical projects that are not yet commenced by NGCP, because we know that there are delays in and some very serious delays in
Hmm.
some of the projects, that if there will be projects that need to be built and NGCP has not done it, that it's it is it possible for another party to build those projects and then turn them over to NGCP. I think that's the area where it's
Right.
being studied. But there
Mhm.
is that exception under the EPIRA for it's happening now. Generators are building their lines, and sometimes even the transmission portion is being built by the generator just to make sure there is no delay when
Mhm.
their plant is ready to start. So there is, in a way, there is already that third party
Right.
in the form of the generators that are
Well,
building
that
certain
would
lines.
simply be something for NGCP to work out with the
Correct.
generator or whoever
Correct.
else is doing the work.
Yes. Yes.
Okay. All right. Well, one last question. I'll ease up on you now.
Uh-huh.
What are some positive things that ERC is working on?
Mhm.
How do you see the outlook for for energy supply and expansion of, or generation capacity
Mhm.
and whatnot for the rest of this year? Are we in pretty good shape? Given we're facing maybe some challenges from El
Mhm.
Nino and things like that.
Mhm. Yep.
Um, and what's your agency working on? What's
The lookout for making sure that we have new supply, new capacity coming in, and whether we have sufficient supply for El Nino is really with the Department of Energy, right? But we do
Mhm.
work closely with the DOE, and to the extent that we can contribute to the programs that will promote increased capacity, we do support aggressively those programs by the DOE. But from our end, what we're excited about for this year, one is really the retail market. We're rolling out because as you know, the threshold right now for the contestable market is 500 kilowatt, 500 kilowatt hours, and considering the operation already of WESM in Mindanao and the physical integration of Mindanao, ARCOA retail competition and open access in Mindanao will also commence soon. That means all areas of the main grid will now be open for contestable market, and that's why we're also coming out with what we call the omnibus rules. For it's no longer just retail competition and open access, but what we call omnibus rules for consumer choice programs. Because then we have ARCOA, we have the Green Energy Option Program, which is the purely RE
Right.
retail supply, and we have aggregation programs that will fall into this basket of programs where consumers can choose directly their own suppliers. We're very excited about that because we think while the issue of affordability is still a challenge we need to face, if large consumers can already contract their own and negotiate their own rates directly with suppliers and generators, that will ease the burden on the part of distribution utilities as well, especially our electric cooperatives who have extreme difficulty sometimes sourcing more affordable rates from suppliers because their loads are really small, so they can't even have that negotiating leverage with generation companies. So at least their large customers can just contract directly. So it's one way of addressing the affordability issue by having large consumers. So that's one, ARCOA. We're also pushing aggressively with our digitalization campaign in the ERC within the institution.
Yeah, that's something you've mentioned before.
Yes, because it's really one tool to promote more transparency, and in that way more accountability on our end. So we're constantly thinking of ways of disseminating information and making it accessible on our website, in the websites of other partner agencies, and we've been partnering a lot with other agencies. We've partnered with the Securities and Exchange Commission that just came out with their streamlined rules for listing for generation companies. We're very excited about that as well. We've partnered with the Philippine Competition Commission so that they can help us also augment our skill set, our personnel in monitoring anti-competitive behavior and market abuses in the WESM. And we have other partnerships in the works for data sharing with the DNR, the DOE, and the NCIP, the National Commission on Indigenous Peoples, all leading towards making it easier for us and faster for us to process permits, issue approvals for power supply agreements, because we can now directly access all the information with the other agencies. So that's just some of them. We need to deal with our backlog. We're hoping we will have significant dent this year by changing the way we do things in our in processing the applications in the office.
Okay, well, we'll leave it there. Hey, your website has gotten easier to use.
Thank you.
Your IT team is doing a good job.
Thank you.
We'll leave it there. Of course, every time I meet with you, there's always a half a day's worth of things we could talk about, but we'll have other opportunities. I really appreciate you taking time out to come down and share with us, and hopefully we'll have a chance to speak with you again soon.
Sure, looking forward to that. And thank you
Thank
to
you.
everyone here and your staff here at Manila Times.